This is a public service.
This is a recording of my oral arguments that I delivered in my Social Security case on July 18th in front of Magistrate Embry Kidd. Your Honor, may it please the court, I would like to begin by apologizing to the court about extending my brief by 5 pages. I didn't understand until submission that the United States motion only applied to them. Your Honor, I would like to spend the next 15 minutes discussing the United States brief. If I could begin by asking why the United States didn't answer perhaps the most important question to this case, Your Honor's question. There's also the question of news purposes and what defines news purposes. I believe there is already a mountain of reasonable doubt, but Your Honor asks a critical question. The case precedent referenced in my brief makes clear it is clearly established that not only does everybody have freedom of press rights, but further that the press and the people have the same right of access. Supreme Court decision Hutchinson v. KQED, Inc., 1978. Justice Potter Stewart stated in a concurring opinion that the First Amendment speaks separately of freedom of speech and freedom of press as no constitutional accident, but an acknowledgement of the critical role played by the press in America's society. He wrote, "The Constitution requires sensitivity to that role and to the special needs of the press in performing it effectively." The fact that the United States ignored this question during their brief is of little surprise, because they made no mention of subsection C of 41 CFR 102-74.420 at any point during the trial. Its absence from their brief raises reasonable doubt. In the United States elements of charged offenses, beginning on page 1, did the United States establish at any point during trial which signs are official and which ones are not? The U.S. inserted a picture of a sign on page 18 of their brief. It is Government Exhibit 9 at the 222 to 235 mark. We know beyond a shadow of a doubt that this sign is unofficial because it says SSA policy prohibits taking pictures. During trial, we established that no such policy exists. I think it is disingenuous for the United States to reference that as some authority when we know this is not an official sign. On page 9, another accusation that I failed to comply with official signage. No authority from GSA or SSA ever made mention of what was official and what wasn't. On page 28, he makes mention of a sign that said, "Please don't stand here." Your Honor, this is what my good friend Dan would call laminator law. These are not official signs, and it is obvious. The United States referenced 2 guilty verdicts in their brief. In the Stamps case, the Honorable Sarah Hayes stated in her ruling on page 5, line 24 and 25, continuing on to lines 1 and 2 of page 6. And the court has reviewed the videotape, as I've mentioned several times, and it is clear that the defendant was allowed and was able to film the entrance, the foyer, the lobby areas where people were sitting. In the Cordova case, I would just like to note that this building sounded like it had a particularly unique layout. The Honorable Michael Hegarty actually noted on page 7 of his verdict, under a different set of facts, where a person might enter from the outdoors directly into a federal office, the outcome could be different. Here, there is a distinct entryway from the outdoors corresponding with a subsection C space, after which was a set of interior doors leading to a distinct, unmistakable office space corresponding with subsections A and B. This is that different set of facts, Your Honor. All parties have stipulated that I was never in an area that wasn't open to the general public. I never enter, nor is it alleged that I ever enter any office space. Your Honor, I mentioned this in my brief, but I would like to touch on it again because the United States made mention that Social Security offices are non-public forums. In Price v. Garland, a D.C. Circuit 2022, the United States argues that the syllogism proceeds from a flawed major premise because not every activity the First Amendment protects as speech benefits from the strict speech protective rules of a public forum. Because the filmmaker does not seek to communicate with others at the location in which he or she films, the filmmaker does not use that location as a forum. Therefore, the United States argues the district court's forum analysis was misplaced. We think the government is correct. Based upon the historical underpinnings of forum analysis, the evolution of this analytical framework, and the cases in which the Supreme Court has applied it, we are convinced that it would be a category error to apply the speech protective rules of a public forum to a regulation of an activity that involves merely a non-communicative step in the production of speech. Although that activity warrants solicitude under the First Amendment, that solicitude does not come from the speech protective rules of a public forum. In reaching this conclusion, we are buoyed by the Supreme Court's warning against extending the public forum doctrine in a mechanical way to the contexts that meaningfully differ from those in which the doctrine was traditionally applied. This is Arkansas Education Television Communication versus Forbes, 523 U.S. 666, 672, 673, 1998. We must remember that I never spoke to anyone that didn't speak to me first. My intent was to silently film. On page 6 of the United States brief, Mr. Del Mastro says that Social Security has a rule. We have proven beyond a shadow of a doubt that this is not the case. Social Security has no such rule. The United States never introduced a rule into evidence. He goes on to say that the rule is the sign, Your Honor. 41 CFR 101-1.110. In the deviation. In the interest of establishing and maintaining uniformity to the greatest extent feasible, deviations, i.e. the use of any policy or procedure in any manner that is inconsistent with policy or procedure prescribed in the Federal Property Management Regulations, are prohibited unless such deviations have been requested from and approved by the Administrator of General Services or his authorized designee. Deviations may be authorized by the Administrator of General Services or his authorized designee when so doing will be in the best interest of government. Requests for deviations shall clearly state the nature of the deviation and the reasons for such a special action. Any no recording policy is prohibited without a deviation, which was never introduced into evidence and doesn't exist. On page 7, the United States continues that while the POMS does not have the force of law, it can be persuasive. I agree, but we should not conflate an audio recording policy that affirms that right into an anti-video recording policy that simply does not exist. The United States argues the fact that SSA's security rule is not set forth in its own regulation is of no moment. The plain language of section 102-74.420 does not require a promulgated regulation or any other particular form 41 CFR 102-74.420 except where security regulations, rules, orders, or directives apply. Emphasis added to or directives. But directives are not merely the random whims of government agents. The GSA defines a directive as an internal directive is a policy or a guideline that is issued by a federal agency for its employees to follow. GSA internal directives provide clear guidance on how to carry out specific tasks or procedures. Internal directives cover topics such as personal policies, information security protocols, the budgeting process. They are often used in response to changes in laws or regulation, or to address specific issues or challenges faced by the agency. Internal directives are an important tool for the GSA to ensure that employees are following consistent and effective procedures and that they are working in compliance with federal laws and regulation. They are the official versions of all internal directives are stored here in the GSA directives library from gsa.gov. No GSA from SSA to GSA was shared in discovery, nor did we see one entered into evidence. On page 8, the United States argues that since the Social Security Administration has been violating citizens' press rights for so long, that they should continue to be able to do so. No thank you, sir. We've identified a problem, and we either need to make the proper changes through the official deviation process, or the United States needs to step in line and do what it swore to do, which was uphold our rights, not attempt to violate them with impunity. On page 13, we have the Operational Readiness Order that says SSA has rules that prohibit photography and videotaping. We have established that SSA has no such rule. This only raises more doubt and highlights the apparent poor communication between these government agencies. Bureaucracy has created this trial of strained logic and mental gymnastics, Your Honor. The government would have us believe that a tenant agency can print up a sign and slap it on a wall and call it a security directive and ignore the GSA regulations and the GSA deviation process. For a few reasons, we know this to be untrue. First, the regulation is written in the plain language, and next is the maxim, what's not included is excluded. And while there is a cutout for a court order or rule, there is not a cutout for a tenant agency rule or directive. The only logical reading of the .420 disallows tenant agency rules, or else tenant agencies could just slap signs on the wall to get around the GSA regulations they don't like, say like the recording in the lobby, for example. Without a deviation, the GSA rules require security regulation, rules, orders, or directives, or a federal court order. These are official actions that are backed by, at the very least, some basic printed documentation, some actual evidence that they exist. The recent Loper decision takes the deference historically given under the Chevron doctrine to the government and restores it to the court. Judicial deference to agency rulemaking under Chevron was incompatible with the court's fundamental duty to interpret the law. On page 16, the United States enters my mind and states that I was there to challenge the SSA video recording policy, not report on the news. Your Honor, we have established beyond any reasonable doubt that no such policy exists for me to challenge. Instead, what I was there to do was see if the people that swore to uphold my rights would honor their oaths. The news in this case is that the people charged with securing our rights have absolutely no issue violating them because I was just following orders. There is nothing more newsworthy. Your Honor, in closing, the question we must ask ourselves is, why didn't the government produce any leases at trial that confirmed we were in agency space? Why did they not subpoena the GSA leasing agent from next door? It's literally connected to this courthouse. The government could have had that one witness come in, review the video, confirm each space was tenant agency space, and what could I have said? Instead, in our case and the two unpublished cases provided by the United States, Your Honor will notice a trend in all of them. In no case has the government provided evidence showing that these lobbies are tenant space. On the other hand, we have submitted the GSA Space Assignment Manual, which without a doubt shows that in no way possible are the common areas ever assigned to a tenant agency. Lastly, and quite possibly most important, Your Honor, is Smith v. the City of Cumming, the 11th Circuit ruling in 2000. The First Amendment protects the right to gather information about what public officials do on public property, and specifically a right to record matters of public interest. To argue that reporting on the behavior of public officials is not in the public interest is frankly absurd. For these reasons, and those cited in my motion to dismiss, the trial, and in my brief, highlight much more than a mere introduction of reasonable doubt. It is for these reasons that I humbly ask Your Honor to find me not guilty of all charges. We're out here today to ensure our natural rights are respected by those who swore an oath to support, protect, and defend the rights of the people. The purpose of all interactions is to peacefully promote government accountability and transparency. Please like, share, and subscribe so this message can reach as many people as possible. I implore you to peacefully seek redress to any and all of your grievances. This is a public service.